So I want you to imagine that you own or operate a business that is under investigation by a federal regulatory agency. And you become aware that the agency has been talking to some of the employees at your company, and you would like to know what they've said or what is being said. Now, if litigation had already started, if the agency had already brought an enforcement action in court, you might be able to get some of that information through pretrial discovery motions. But if we're still in the investigation stage, you're unlikely to know who the agency has talked to or and what those people uh, said to the agency representatives. And maybe you want to know this because you would like to prepare for an eventual enforcement action that's coming, or you would like an opportunity to rebut the bad things people are saying about you. So you request the information under the Freedom of Information Act, saying the agency has information that from interviews they've done or surveys they've conducted of our employees, and the agency doesn't want to give that information because unsurprisingly, they think that you're going to retaliate against your employees who have been cooperating with the agency during the investigation. And so that's the basic plot of the case that we're going to be talking about in this video, the National Labor Relations Board versus Robbins Tire and Rubber Company. This is a 1978 case that went to the U.S. Supreme Court about the Freedom of Information Act and Exemption 7 under that act, which is for law enforcement records and public safety. So let's dive in. So just to frame the issue for you at the outset of our discussion, in this case, the Supreme Court is addressing whether the Freedom of Information Act requires the National Labor Relations Board, or NLRB, to disclose witness statements prior to an unfair labor practice hearing. So what's going on here is we have a statutory framework that protects labor unions and workers who are trying to organize into a union, and it protects them against interference from the management that might be hostile to having a unionized workforce. And that's what was happening here. There were allegations that Robbins Tire, that their management was somehow interfering with the organization of union activities, and they wanted information about who was cooperating with the NLRB. So we have a body of law here, just to give some background, on the federal level that gives certain protection to workers who are trying to unionize because employers and managers are notorious, if left to their own devices, about retaliating against or terminating employees who are trying to organize a labor union. And among the details of these rules, or one specific provision, we have some about the election of union representatives that's designed to ensure that this is fair and actually represents the wishes of the majority of workers, and that there hasn't been any interference with the management in trying to manipulate the election of union reps to get people that are loyal to the management in charge of the union. So there was a contested union rep election at this plant for Robbins Tire. And the NLRB was doing an investigation and was planning to charge Robbins Tire and Rubber Company with unfair labor practices. So Robbins Tire requested copies of all the witness statements from their employees 7 days before their scheduled administrative hearing pursuant to the Freedom of Information Act. Now, again, keep in mind, if we were in court, a regular court, the rules of civil procedure would probably provide for some pretrial discovery, at least about the witnesses that are going to be called or witnesses whose testimony is going to be submitted as evidence. But the rules of civil procedure don't apply to administrative hearings, which is the stage that we were at in this case. And Robbins Tire wanted to know who had said what from all of their employees to the agency a week before the hearing. So the acting regional director for the NLRB denied the request from Robbins Tire and Rubber, and they did so relying on Exemption 7A to the Freedom of Information Act. 7A, just to remind you, exempts investigatory records compiled for law enforcement purposes if disclosure would interfere with enforcement proceedings. So that was basically, we're not going to turn over the list of witnesses from your employees and who said what, because it would interfere with our enforcement proceedings. Don't get too hung up on this, but just keep in mind, in terms of background, the district court had ordered the release of the statements. In other words, it had sided with the employer, Robbins Tire and Rubber Company, and the Fifth Circuit Court of Appeals had affirmed, which eventually led to the appeal to the U.S. Supreme Court, and the court granted cert. Part of the court's analysis of the issue in this case was to note that Exemption 7A under FOIA, unlike some of the other subsections of Exemption 7, speaks in the plural. It talks about it would interfere with enforcement proceedings. And that suggested that Congress contemplated what the court calls generic determinations of interference rather than requiring a case-by-case showing for every document. What was Congress's intent with enacting this exemption? Well, Congress had originally enacted Exemption 7 to the Freedom of Information Act to prevent harm to the government's case and to avoid litigants getting earlier and greater access to agency investigatory files. In other words, that if people, while the investigation is going on, before we've even had our first hearing, they could do things like intimidate or threaten witnesses or destroy documents or so forth if they knew everything that the agency had in building their case while the investigation was still underway. The court here specifically looked at legislative history and statements that were made by Senator Hubert Humphrey, who eventually became vice president, who had told the rest of Congress that Exemption 7 was specifically intended to protect against mandatory disclosure of witness statements, the very issue in this case prior to unfair labor practice proceedings. And so the facts of this case had been specifically contemplated and presented to Congress while they were deciding whether to adopt Exemption 7, the disclosure of witness statements prior to unfair labor practice proceedings, because they didn't want managers to threaten or coerce or intimidate the employees who were cooperating with the agency. On the other hand, there had been some amendments to the FOIA statute in 1974, specifically to Exemption 7, to try to prevent just blanket exemptions for entire investigatory files. In other words, they didn't want it to be used too broadly by the agencies. But the court held here that the change did not preclude courts from determining, in some cases, that disclosure of specific investigatory records would indeed interfere with enforcement proceedings. So what types of things are we worried would happen if the NLRB had to tell the employer a week before the hearing who had said what among the employees? Well, as I've mentioned already, there's a fear of intimidation or coercion of the employees or other witnesses, like maybe vendors and of the company and so forth, who might change or refuse, change their testimony, recant, refuse to testify at the hearing, and so forth. Also, if there are other employees who haven't talked to the agency yet, if word gets around that the agency is going to tell your employer that you cooperated with them and what you said, that they're going to turn over your witness statements, it might make people hesitant to cooperate with the agency or to come forward with additional information. And it would be really disruptive to the NLRB's longstanding practice and procedure. And the problem with that is that it would cause a lot of delays in this case and other cases, and the court didn't want that. So what was the holding in this case? The Supreme Court held that the National Labor Relations Board had actually met its burden for being able to invoke Exemption 7A. It said that pre-hearing disclosure of these potential witness statements in an unfair labor practice proceeding would indeed interfere with enforcement proceedings. Because the court found that disclosure was likely to interfere with enforcement proceedings, it continued in its holding to say that that means that this information is exempt from FOIA disclosure under the statute, at least until the completion of the hearing, and that FOIA was not intended to function as a private discovery tool for companies that are the target of an investigation. So where does this leave us? Even though we have de novo review by the courts here, and the agencies actually under FOIA bear the burden of proof when they don't want to disclose information, the Supreme Court's decision in Robbins Tire and Rubber effectively granted agencies the ability to make pretty generic determinations of certain types of records, that those would interfere with enforcement proceedings if they were disclosed. And so you could kind of put this case in the column of giving deference to agencies, at least for the point of the potential harm that could arise from disclosing these documents in response to a FOIA request. Also, just to make this a little bit confusing, the Supreme Court later on drew a distinction between Exemption 7A and Exemption 7D, and said that Exemption 7A, like in Robbins Tire, permits a generic approach to categorizing documents as not subject to disclosure under FOIA, but the Supreme Court rejected this kind of broad generic presumption for Exemption 7D, which I'll talk about in another video, in the United States Department of Justice versus Landano. In the Landano case, the court rejected this blanket presumption of confidentiality for all the sources in criminal investigations, and decided that instead it would weigh several factors against each other, like the source's relation to the crime and so forth. They still allowed a narrower categorical approach to these refusals to disclose information. For example, paid confidential informants, the agency doesn't have to reveal their identities and so forth. So I'm not going to make a whole video about that case, but you should be aware of it, that it's discussed in the casebook I use for my course in the notes after the Robbins Tire and Rubber Company case. So that brings us to the end of our discussion of the NLRB versus Robbins Tire and Rubber Company. Thank you for watching.